everyone. For those of you that don't know me, my name is Heather Haven, and I'm the Associate Dean of Research and Graduate Studies here at the College of Law, and I am also a member of the College of Law's Guest Speakers Committee. Before we begin, we would like to acknowledge that we are on Treaty 6 territory and the traditional homeland of the Métis. We pay our respects to the First Nations and Métis ancestors of this place and reaffirm our relationship with one another. It gives me great pleasure to welcome you to the College of Law this afternoon. This event is part of what we call our McKercher Lecture Series, which allows us to offer free public talks on a wide range of topical issues and attract a great variety of guest speakers to the university, to the College of Law, and beyond to engage us and to enlighten us. Without further hesitation, I'd like to introduce our guest speaker. Kent Roach is a professor of law and Prichard Wilson Chair of Law and Public Policy at the University of Toronto's Faculty of Law. He teaches courses in criminal law and wrongful convictions, and his research expertise spans comparative criminal law, comparative constitutional law, national security, and anti-terrorism law and judicial decision-making. Professor Roach is the author of 13 books and over 200 academic articles. He has won awards for his pro bono work and contributions to civil liberties, representing Indigenous and civil liberties groups in many interventions before the court, including Gladue, Wells, Ipili, and Anderson, pertaining to sentencing of Indigenous offenders. He represented Aboriginal Legal Services of Toronto in jury selection cases of R versus Williams and represented the David Asper Center in R versus Cacophonous. He also worked with the Truth and Reconciliation Commission on its legacy volume. Professor Roach is a graduate of the University of Toronto and of Yale Law School. He is a fellow of the Royal Society of Canada, and in 2015 he was appointed a member of the Order of Canada. So we are delighted to have Professor Roach with him. Please join me in welcoming him.
Thank you very much, Heather, for that generous introduction. Everyone can hear me? Okay. Okay, so I'd like to also affirm the greetings that Heather gave and acknowledge that we're on Treaty 6 territory in the homeland of the Métis, and also reaffirm the need for respectful relations between all of us as treaty people. I also would like to preface what I'm going to say by recognizing that the last 3 weeks have been a very painful time, and some of which I will discuss, alas, will also be painful. This is the plan. I hope to talk for no more than 40 minutes and leave lots of time for questions. I want to start off by talking about the role of the jury in fact-finding. I then want to put a little bit of historical context so we can understand that the Stanley Busche case was not the first case where there have been jury trials without Indigenous persons. I think it's important for us to understand that history. Then I'm going to talk about 3 aspects of jury selection: summoning the jury panel, challenge for cause, and peremptory challenges. And I welcome the opportunity to be here and to have 40 minutes to talk about them, because they're complex and interconnected. And sometimes public discussion of them in the media gets distorted and gets perhaps needlessly polarized. Although you were promised that I would discuss jury abolition, I'm not. Juries for accused who face 5 years imprisonment or more are guaranteed under Section 11F of the Charter. Now, just to own up to my historical record, and I'm of an age where I have a historical record, in 1992, and I just reread it. I don't usually reread my op-eds. One of my first op-eds as a very young law professor was written literally while Los Angeles was burning after the acquittal of the police officers who beat Rodney King. And I wrote a piece in the Globe and Mail, it got me lots of hate mail, about juries outliving their usefulness. I think as the years go by, I probably have reevaluated that a bit, right? In 1992, I was 3 years out of a year of clerking with Justice Bertha Wilson, and I thought that all judges were like Justice Wilson. And so I thought judges were pretty good. Now as I get older and my friends and colleagues and peers become judges, I also recognize that they have, like all of us, certain frailties. So I'm not here as kind of the Toronto elitist to say we should get away with juries. I want to contribute to a debate about improving the system. And as I age, right, if we have diverse juries, if we have truly representative juries, again, that doesn't give you any guarantees, but the fact that the jury can only bring in a verdict if it is unanimous, that's an interesting and perhaps promising facet of the jury. Now, do any of the law students or lawyers know who this judge is? No? No bonus points? Okay. This is Judge Corrine Sparks, who was the first African-Canadian judge appointed to the Nova Scotia Provincial Court. The law students might know this through the RDS case in 1997. And in the course of acquitting a 15-year-old African-Canadian of assaulting a police officer, she made the following comments. Police officers do overreact, particularly when they are dealing with non-white groups. Psh, everything kind of exploded. The case went up to the Supreme Court of Canada, and in a 6-3 decision, they affirmed Judge Sparks's acquittal and rejected claims of reasonable apprehension of bias. But it was a very, and those of you law students who have studied it know that this is a very contentious decision. 2 of the 6 who held there was no reasonable apprehension of bias concluded that her remarks were close to the line, while 4 of the 6 said that they were quite proper, that they were a proper approach to contextualize judging. And of course, 3 judges felt that that was inappropriate and revealed a reasonable apprehension of bias. The reason why I start with this, right, is in law school, we teach you the law, but we don't teach you an awful lot about how people make factual determinations. And that's really what we're talking about when we're talking about the jury. So the role of the jury, and we saw this in the Stanley Busche case, is to make determinations of fact. And unlike Justice Sparks and unlike trial judges who have to articulate why they make determinations of fact, what life experience, what reasoning process do they draw upon, the jury doesn't do that. The jury simply delivers a unanimous verdict. And indeed, under Section 649 of the Criminal Code, and this is very different than in the United States, it is an offense for a juror to disclose any of their deliberations, except in the very narrow exception of an investigation or a trial for obstruction of justice. So unless someone's kind of tampering with the jury, threatening the jury, bribing the jury, we're never going to know why the jury made the decision that it did. And Canadian law puts a very, very high value on the secrecy of jury deliberations. And indeed, in R versus Pan in 2001, in a decision written by no less than Justice Louise Arbour, the court said even if there are comments that some of the jurors in that case made racist remarks as part of the jury deliberation, we don't go inside that opaque box of the jury's determination of facts. So we're never going to know, unless some reporter and some juror breaks the law, why the jury acquitted Mr. Stanley of murder and manslaughter. We know from reading the trial judge's charge to the jury that there were many questions that they had. I'm not going to go too much into this case, but how did the jury make determinations about hang time? How did it think about the relevance of the criminal record of two of the witnesses that were left to them? And how did it apply the judge's unexplained reference to lawful excuse for a careless use of a firearm, which was one of the bases that might have led them to a manslaughter conviction, even if they accepted that the killing was accidental. So, judges give reasons, and there's a debate about whether after RDS judges are going to be as candid as they should be about their reasons, but juries do not. And that's probably not going to change anytime soon. I mean, we could go to the system that is used in Europe, where judges and jurors and lay jurors and judges sit together, but that's not the jury system we have. And given that opaque box and that problematic box of fact-finding, which we don't really train you as lawyers to be, it makes fairness and inclusivity in jury selection even more important. And next, I want to talk about the historical context. This trial happened in Battleford. Something else happened in Battleford in 1885, which is still very much with us in Saskatchewan. What happened in 1885 was a murder trial of 6 Cree and 2 Assiniboine men at Fort Battleford without counsel and without interpreters, and before all-white juries described by Blair Stonechild and Bill Wazer as the same persons who had lived in fear of an Indian attack during the rebellion. These were political trials. Whatever you think, and I know that I'm not here to defend Prime Minister Trudeau, but whatever you think about what Prime Minister Trudeau and Minister of Justice said, it's child's play. It pales in comparison to what Sir John A. Macdonald did in taking an active interest in that trial, in ensuring that they were charged with murder so that they could be hanged, and writing a few days before the execution of the Indians ought to convince the red man that the white man governs. That's political interference. That's part of the historical legacy, and it's one that I think in this province, probably more people are aware of, but it is, I think, an important legacy. Now, moving more into the future, what other issues have we had with juries who have been involved in cases with Indigenous people, either as accused or as victims? And we know that they are dramatically overrepresented in both of those categories. That's very clear. What are the other cases, the other historical cases that you should know about with juries that did not have any Indigenous people on them? Donald Marshall Jr., you've seen lots of pictures of Donald Marshall Jr., the late Donald Marshall Jr., after he got out of prison and when he did a landmark treaty right case. This is what Donald Marshall looked like as a 17-year-old when he was arrested in Sydney, Nova Scotia in 1971. And this is a case that I have taught every year since 1989 to my criminal law students. And I will continue doing that until I stop teaching criminal law. Donald Marshall was wrongfully convicted by an all-white jury. And one of the reasons why I teach this case to my criminal law students is it's really a case not about the facts, not about the law, but about the facts, right? It is about the facts. Donald Marshall Jr. testified. He testified about what happened, which turned out to be truthful, that he had been stabbed by two other men, and Sandy Seal, who was the victim, had been fatally stabbed. He was the person who flagged the police down. And then there were three other witnesses, young people like Marshall, but not Indigenous people, who had been badgered by the police into falsely testifying that they saw Marshall stab Seal. And despite the reasonable doubt standard, the jury convicted Marshall. And as a 17-year-old, he went to Dorchester Penitentiary, and he didn't come out for 11 years. And at that time, no Indigenous person had ever served on a jury in Nova Scotia, and indeed, probably in most of the rest of Canada. So that's part of the history that we're dealing with. The other part is the Helen Betty Osborne case. And the Helen Betty Osborne case from the PAW was a case where the Manitoba Aboriginal Justice Inquiry found that at the time there was about a 30% Indigenous population in the district. The panel of prospective jurors in the Helen Betty Osborne case was about 18%. So there's a slippage right there. But it didn't, in some ways, it didn't even matter. And why didn't it matter? Because the defense lawyers, between them, were able to use peremptory challenges to take all 6 Indigenous people that came up on the jury roll. They were kept off of the jury. Now that case was in some ways a split verdict. There were 2 co-accused. One was convicted of murder, and one was acquitted. But in 1991, the Manitoba Aboriginal Justice Inquiry, after examining this case, made a recommendation, one that I agree with, that we should have gotten rid of peremptory challenges. And if we had gotten rid of peremptory challenges at that time, I dare say the jury in the Stanley Busche case might very well have been quite different. Okay, so let's now back up and talk about those 3 complex and interconnected things that go into jury selection. The first is summoning the panel. of prospective jurors. The second is challenge for cause, and the third is peremptory challenge. So the summoning the panel, what do we know? We know that about 750 people were summoned to go to Battleford in the Stanley trial. About 200 showed up. We have no information. We don't collect information about how many of those people were Indigenous, but other information that we have from other sources suggests that probably Indigenous people were less likely to come to Battleford for jury service. In the Cacophonous case, the Supreme Court decided 5-2 that a jury panel in Kenora, which is, as you know, in Northern Ontario, was constitutional, even though only 8 of the 175 people who were summoned to possibly be jurors in Mr. Cacophonos's murder trial lived on reserve. Justice Moldaver, for the majority, held that that was constitutional. He stressed that the issue was simply process, that had Ontario, and it is the province that has the responsibility for summoning jurors, that as long as Ontario had made reasonable efforts and didn't deliberately exclude people from the jury panel, that was all that could be expected. That was all that could be expected, and the results of who showed up were not relevant, in Justice Moldaver's view and the majority's view, to the charter analysis. And so there was very well documented rates of non-returns from Indigenous jurors. There were problems in getting ban lists, but even when the ban list was obtained, many Indigenous people, for a variety of reasons, just simply didn't answer the jury summons. And you should go back and read Cacophonous in light of the Stanley Busche case, because I have to say, and I was involved in the Court of Appeal. I was actually not. I represented the David Asper Center in the Court of Appeal. I wasn't in the Supreme Court. I'd like to think that the result would have been different, but of course it wouldn't have been. But if you reread that decision, Justice Cromwell writes a dissent, and a dissent that really got under Justice Moldaver's skin, because the court started going at each other in kind of an American-style way. And Chief Justice McLaughlin agreed with Justice Cromwell. And if you read that dissent in light of Stanley Busche, to me, it was very poignant, right? Because Justice Cromwell says the unintentional yet substantial underrepresentation of Indigenous people on the jury inevitably, in my view, casts a long shadow over the appearance that justice had been done. And Justice Cromwell said reasonable efforts is not enough, right, when it comes to complying with the charter. Those of you who are studying charter know that we look at effects, right? What is the effect of state action, not simply whether state action has a good purpose or has reasonable efforts. The issue of summoning juries is a problem everywhere. This isn't simply a Saskatchewan problem. The Toronto Star just a week ago published an excellent research study where they looked at 52 trials in Toronto and Brampton. And they found that 7% of the jurors in those trials were black, 7% were brown, 14% were Asian, and 71% were white, and only 22% of the accused were white. So it's been said in your papers, right, that the juries of Saskatchewan are often Indigenous accused and white jurors. This is a problem where I come from too, because Toronto is a city now where visible minorities are now the majority. And yet, for a variety of reasons, the best evidence that we have is that in 71% of the jurors are white. Saskatchewan actually uses health care, not property, and pays jurors more than most provinces. But they're still under representation. And Justice Iacobucci, in his report on the Northern Ontario experience, concluded that there were many reasons for this. The distance, right? So traveling to Battleford, the expense, exclusion of people on the basis of criminal record, and then also, and I think that this is probably the most important, simply the alienation. Why, as an Indigenous person, would you want to be part of a criminal justice system that both imprisons your children, your cousins, your friends at a grossly disproportionate rate, and also fails to protect them, particularly Indigenous women and girls, from violence? And Justice Iacobucci, as he traveled throughout Northern Ontario, said, you know, look, the jury issue here, this is the canary in the coal mine. There is a much more deeper rooted sort of problem. And it was for that reason that Justice Iacobucci recommended all sorts of kind of systemic reforms that were really based on more of a nation-to-nation respectful relationship with Indigenous communities. Because he just found that, you know, their Indigenous people were not buying into the system. And they had good reasons not to do so. Now, there are some interesting experiments. So here in Saskatchewan, Section 29(3) of the Coroners Act has been amended to allow juries with specific groups. And this was one of the things that Justice Iacobucci recommended be looked at in Ontario, and then the main Indigenous governance group in the North is working on using volunteer jurors, people from the Indigenous community who want to actually be on juries. Now, there is fierce resistance from some Crowns and some defense lawyers about this, right? That they argue that, you know, the jury cannot be a volunteer. But I actually think that we need to look at that. And we also need to realize that there is still a challenge for cause possibility if a person is not impartial. I don't think we can assume that because someone volunteers that they are not impartial, but there is that safety valve. And so the first kind of criminal code reform, and one of the reasons why I'm here is I'm hoping, don't know how optimistic I am, but I'm hoping that the federal government will address this issue. And the first criminal code recommendation that I would recommend is to amend Section 629 of the code, which is a provision that allows the accused or the prosecutor to challenge the jury panel of all the prospective jurors, but only on the basis of partiality, fraud, or willful misconduct. And, it's the last kind of vestige of intentional sort of discrimination thinking. It's been in the code since 1892. And it seems to me that if the code was amended to allow challenges to jury panels on a substantive equality and effects-based basis, that this would spur the provinces and territories to work with Indigenous communities in order to have more representative panels. Another thing I think we need to do is rethink some of the categorical exclusions, again, that have been around since 1892 and are found in Section 638 of the Criminal Code. So if you're not a Canadian citizen, if you're an alien, and that's the word the Criminal Code uses, so don't blame me, you're not allowed to be on a jury. And, especially in a place like metropolitan Toronto, that's also part of the explanation for the results that the Toronto Star found. We also have a provision in Section 683 that says if you've been sentenced to death or you've been sentenced to 1 year imprisonment or more, that you're not eligible to serve on a jury. I mean, talk about archaic provisions. That's been there since 1892. Let's get rid of that, right? The Saskatchewan Jury Act is, I think, more progressive in only excluding those who are in prison. I guess if you really want to take a shot at me at questions, we can talk about the prisoners' voting rights case. I was also involved in that, but we don't need to kind of go there. And then also the English and French requirements. Both Quebec and the Northwest Territories are experimenting and have provisions that allow jurors who are most comfortable in their Indigenous language to serve on juries with proper interpretation. So there are things that can be done, right? And there are things that can be done that even if you disagree with me violently on peremptory challenges, and I'm expecting that some people will, maybe you might agree with some of the other things. Now the next thing, and in some ways I think this is even more important than what I'm going to say about peremptories, is the issue of challenge for cause. This was one of the first cases I did it. I was counsel on in the Supreme Court of Canada, and I will always, till the day I die, remember Victor Williams' affidavit in that case. It was the shortest and most elegant thing that I ever had seen. Victor Williams was a person, later found out, had FASD, who was charged, Indigenous person, charged with robbery in Victoria. And Victor Williams' affidavit said, "My lawyers have explained to me that there are going to be no Indians on the jury. I just hope there's no Indian haters." And to me, that was that whole case, right? I mean, I'm a big Bruce Springsteen fan, and one of my favorite things is, the poets down here don't say nothing at all. They just, stand back and let it all be. And to me, that case was probably won just by putting that affidavit before the court. And the court unanimously, in the Williams case, allowed questions for racism against an Indigenous accused on the basis that there was a realistic possibility of bias. And this was seen as a big deal, right? I mean, when you think about, can we have a jury system without peremptory challenges? The time of Williams, a lot of people thought, we can't do this. This is going to make us into an American system where you have, multi-page questionnaires. But we kind of got over that, and the Williams question now is part of our law. But one of the things, and again, I think this is the most important thing that I'm going to say today, is the Williams question is also available to the Crown. So challenges for cause are both for the accused and the Crown, and there are no limits on those challenge for cause, because we don't want jurors who are not impartial. We want jurors who will decide the case on the basis of the evidence as it is presented to them. And in a case called Rogers, and it's reported there, and I looked it up recently on CanLead, it's only been cited in one other case, which is a little bit disturbing. The Crown, and this was not done in the Stanley case, the Crown sought judicial permission and was granted judicial permission to ask potential jurors whether their ability to decide the case on the basis of the evidence impartially would be affected by the fact that the accused was white and the complainant, the victim, was Indigenous. And this is what Justice McKinnon said in this very important case. Racism will be at work on the jury panel as soon as the victim is described as Aboriginal. I do not agree with defense counsel's submission that the question proposed would be counterproductive in that it would inject racial overtones into a case where none previously existed. A question directed at revealing those on the panel whose bias renders them partial does not inject racism into the trial, but seeks to prevent that bias from destroying the impartiality of the jury's deliberations. And in Horse, the Saskatchewan Court of Appeal, in a case dealing with lack of Indigenous representation on the jury, said the Williams question was very important to ensuring the fairness of the trial. And the Williams question, as asked by the Crown and as applied to Indigenous victims, is, in my view, not inconsistent with subsequent jurisprudence from the Supreme Court, such as Fine. So I think that one of the things that Parliament should consider is amending or encouraging and educating under Section 638 that those questions are there both for the Crown and for the accused. And Williams talks about deep-rooted and subconscious racism, but it only allows, because of course that was the first step, it only allows one very blunt question that basically is, are you a racist? And why not allow a series of sort of questions in order to get to this issue? And again, I say this, right, because once the jury's picked, we're not going to have anything else from the jury. We're not going to know why the jury made its decision. So we got to get it right going in. Then we come to peremptory challenges. So both Mr. Stanley and the Crown had 14 peremptory challenges because it was a second-degree murder trial and alternative jurors were picked. If it wasn't that, there would normally be 4. First degree, there is 20. Now, peremptory challenges have a long, somewhat controversial lineage. They actually were first done more as a way for the Crown to kind of make sure that they had the right sort of people on the jury. But William Blackstone talked about them as, shows the favoritism of English law towards the accused, and described them this way, that it was an advantage to the accused that they not be tried by any man against whom the accused has conceived a prejudice, even without being able to assign a reason for for his dislike. So even if you go back to Blackstone, it's not just me that calls peremptory challenges an invitation for discrimination. It's William Blackstone. But he thinks it's okay because it's for the accused. I don't think it is, because I think equality kind of cuts both ways. And the argument from the English common law is kind of undercut by the fact that the UK abolished peremptory challenges in 1988. And life went on. Life went on. Now, the Americans have tried to regulate peremptory challenges, starting in a case called Batson, but most commentators conclude that this regulation of the use of peremptory challenges has not only added time to criminal trials and jury selection, but it's actually not been particularly effective, because all the prosecutor and now all the accused, because it has been extended to the accused use of peremptory challenge, all they have to do is come up with a facially neutral reason other than I'm putting this person, I'm excluding this person because of his or her race. Today in the Globe and Mail, there's discussion about the Cornell case, which is from the Yukon, which is really the only case that I'm aware of where we've had a charter challenge to a discriminatory or an alleged discriminatory Crown use of peremptories. And one of the interesting things about the Cornell case is that there was also a challenge by the Indigenous accused to the jury panel, because there was underrepresentation of Indigenous people on the panel. And the challenge was denied because there wasn't enough of an evidential base. Well, according to today's reporting in the Globe and Mail, although the Crown said, well, I just excluded the person, I didn't know that person was Indigenous. They did know that one of the excluded people worked for the band. So, I mean, we can go down that route, and I'm a little worried that that might be the way we go down that route. But I don't think it's going to be effective, and I think that it is going to add time to criminal trials, right? I mean, we've had the charter for a long time. This is the only case, and it's a case where it's much easier to challenge discriminatory use of peremptory challenges by the Crown, by the prosecutor, than it would by the defense, right? I mean, if the Crown's going to have to challenge that because the complainant probably doesn't have standing in the criminal trial, they're going to have to not only lay a factual basis, but establish that there's state action under Section 32 of the Charter and establish a Section 15 violation. That's asking an awful lot. So it seems to me that the way to go, right, and why I worry that we're going to go down this route is that Justice Iacobucci didn't recommend the abolition of peremptory challenge, but he said we have to deal with the discriminatory use, because he came to the conclusion, which I totally agree with, that if peremptory challenges remain, it doesn't matter anything we do to increase Indigenous representation on the jury will be for naught, because peremptory challenges will result in or discriminatory use of peremptory challenges will result in Indigenous people being excluded, not for articulated reasons, but simply because of the way they look and the unarticulated feelings of either the Crown or the defense. And that's why I think the Manitoba Aboriginal Justice Inquiry, and before that Justice Thurgood Marshall, was exactly right, that the only way we're going to deal with this is to abolish peremptory challenges. Now, I realize that this is going to be opposed by some defense counsel and some Crown counsel. There's two kind of arguments that I've heard. One is that we need peremptories because challenge for cause don't always work out are fallible. That we need peremptories because sometimes after the challenge for cause, even though the two triers say the person is impartial, we don't think the person is impartial. So we have to use that peremptory challenge to get that person off. Well, if that's the issue, and I agree that partial people should not be on the jury, let's use the right tools. Let's try to expand the challenge for cause. Let's introduce perhaps more of a judicial role in the challenge for cause. Under Section 632, judges also have an ability, although right now they can't usurp the role of the triers, who are two jurors who decide whether the challenge for cause is made out, but there's grounds for expanding the challenge for cause. So if a Crown and a defense lawyer tells me I need a peremptory challenge because that's the only way I can ensure an impartial jury, my answer to them is, let's work on Section 638. The second reason that I've heard, and I'm a bit more skeptical about this, is some defense lawyers have argued, I use peremptory challenges to get a more representative jury. Well, that may work maybe on gender issues, right? But if it is an underrepresented minority, you only have so many peremptory challenges. There were 14 in the case that we're talking about. In many cases, there are only 4. So 4 are not really going to get you that way. And if you're genuinely concerned about the representativeness of the jury, then let's work with the provinces and with Parliament to have a greater ability to challenge the representativeness of the jury pool. Let's overrule Cacophonous. I think Cacophonous is a bad decision. I started my law career at a time when the Supreme Court said stupid things like pregnancy or discrimination on the basis of pregnancy is not discrimination against women, it's discrimination against pregnancy. And Parliament reversed the Supreme Court, even though that was a Canadian Bill of Rights decision. There's nothing that prevents Parliament from adopting the Justice Cromwell effects-based standard as the standard in the criminal code. So those are the two arguments. There may be other arguments that we hear. I'm trying to be respectful to members of the bar who feel strongly about this, but I have to say, I don't find those two arguments to be particularly persuasive. So in conclusion, I'm not here to say that jury reform is going to be sufficient to ensure justice for Indigenous people. I know you're going to have other panels that look at Indigenous justice and Indigenous law, but I was asked here to talk about juries, and I think that there is a moment in time where, you know, it's very hard to think of good things coming out of the last 3 weeks. And maybe this isn't even going to be a good thing, but this is what I do, and this is what I offer. And so for me, if we want to make the jury process fairer, if we want to increase the widest public confidence possible in the jury, we need to do 5 things. And the federal government can do those 5 things before the summer recess if it really set its mind to it. I've seen the criminal code amended really quickly, really quickly, and when a government wants to. Abolish peremptories, expand the grounds for jury service, including volunteers, expand the ground for challenging the representativeness of panels, and put pressure on the provinces and the territories to work with Indigenous communities on a nation-to-nation basis so there are more Indigenous people on the panel. Expand the grounds for challenge for cause. If you really think that you need peremptories to ensure an impartial jury, seems to me the real issue is challenge for cause. And allow for more judicial intervention to ensure that we have impartial and incompetent juries. Thank you very much for your attention.